person can be convicted solely on circumstantial evidence.
What rights are we protecting from innocent people being charged?
And ladies and gentlemen, how on earth is this proof beyond a reasonable doubt? You cannot convict this man.
That is wild. I have never heard of that.
Sloppy, for sure.
Welcome back. Here we are doing another podcast. Dave, how you doing?
I'm good. Can you believe that we've made this into a series now?
I know.
We're on a roll.
This is fun.
Yeah.
This is fun. I'm liking it.
I love it.
Well, very cool. Well, today, why don't you talk to us, just kind of overview what case are we going to be looking at?
Yeah, so we've kind of stuck on this theme of homicides. At some point, I think we ought to move to different kind of cases, but we're going to I shouldn't say attack. We're going to analyze another homicide case. We just finished our series on the baseline killer. This one is a case out of Yavapai County, Prescott, Arizona. They say Prescott, not Prescott. It looks like Prescott, yeah. But anybody who's from Arizona knows that it's Prescott, Yavapai County. This is a case from 2008. The defendant is Steven DeMocker. He was convicted of, hope I'm not spoiling things.
Spoiler alert.
Right to the end. And he's convicted. So he was convicted of murdering his wife, ex-wife, Carolyn Kennedy.
Which was it was a very recent divorce. So
it was. And so with this case, the facts are, I'm not going to say complicated, but there's a lot of elements to the facts. So rather than read from the Court of Appeals opinion, we're going to kind of break them down one by one.
Yeah, let's do it kind of a little bit differently than we've done it before, rather than kind of reading the dry facts and then talking about each of them. I think this case just lent itself to doing it a little bit differently. So hopefully this is a better way in this case for it to kind of make sense as far as how it came out and then into the trial.
I agree. And one thing that we need to sort of frame for our viewers and listeners is the idea of what circumstantial evidence is. You agree?
Yeah, I think that's kind of I don't want to say the theme. I mean, it's just a big piece of this case is that, like in the Court of Appeals, when it's talking about this case, and anybody who reads these Court of Appeal opinions generally is going to do a facts section of what it's about. The very first thing that they say is, this is only a circumstantial, I guess it doesn't use the word only. It says this is a circumstantial case.
That's right. And so what does that mean? Because sometimes people have the opinion of, well, it's a circumstantial case, then I can't be convicted.
That must mean it's no good.
Yeah. Right. And so this, I think, one of the propositions that the DeMocker case stands for is that you can be convicted, a person can be convicted solely on circumstantial evidence.
Meaning no physical evidence.
Well,
or I should say
direct evidence. Right. So I'll read what the jury instruction is, and that'll frame for our viewers what we're talking about. So we've talked about jury instructions in the past. Here's what the standard criminal instruction says about circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it's direct or circumstantial. So a jury has to give value or weight to whatever the evidence is, be it direct or circumstantial. What's the difference? Direct evidence is somebody who sees something, right? And then they testify, I saw, this guy murder that person, right? That's direct evidence. Circumstantial evidence is indirect, meaning it could be a fingerprint or some DNA left behind that gives rise to an inference that something happened or that something can be proven, but it's not direct proof of that thing.
Right. And even physical evidence can be direct or circumstantial, right? And,
sure.
And we actually see that in this case. There's a 48 Hours episode that talks about there's no physical evidence in this case.
Right.
There really is, but it's not direct. Like you said, it doesn't directly prove that he committed the crime. It just will prove one fact, such as potentially somebody with the same tires was behind her house at some point recently. And so then they can draw other inferences from those facts.
And the reason that's important is because this, like the baseline killer, was a whodunit, right? Carolyn Kennedy is found by police. She is dead in her home. She has some wounds to her head. There's blood everywhere. And the question is, who did it? Okay, so maybe, Ryan, start with that fact. How did police happen upon her body?
Right. So Carolyn, she was on the phone with her mother, and she was in her home in Prescott. And suddenly she makes an exclamation, basically says something like, "Oh no," and screams or sounds surprised. It's unclear exactly what was there. There's no recording. And the phone goes dead. And her mother's very concerned. She keeps calling her back. She's not answering. And so she calls police, grandma, or her mother does, and says, "Hey, this is what happened. Please go check on my daughter." So police check on her, and they can actually, just from the outside, looking through the window, can see somebody who's apparently clearly deceased, face down in her own pool of her own blood. And then they make entrance into it. And there's some discrepancy on some accounts of it where police maybe apparently first thought it was an accident because there was a ladder nearby. It looked like maybe she fell down, and there was no sign of forced entry. But it seems that very quickly, just the brutality of the scene, there was, like you said, blood everywhere, even on the far wall of the room.
I think it's helpful. I think it's helpful to read those specific facts, because you're absolutely right. Cops get there. It appeared the victim had fallen from a ladder and hit her head. No signs of forced entry. Bookcase and ladder tipped over as if she had fallen. But on closer examination, deputies began to suspect the scene may have been staged. Bloodstains on the carpet indicated the victim was moved after she began bleeding. The ladder did not have blood on it, suggesting that it was positioned there after she'd been killed. And the wounds to her head, as you described, were multiple blunt force trauma to the head. Appearing later, I think, they determined it may have been caused by a golf club, which we'll get into. So that's the scene. Okay. Now, that's on July 2nd, 2008. Let's roll back the clock a little bit, because context is really important here.
Especially in this case. With circumstantial evidence. Yeah.
So Carolyn Kennedy and Steven DeMocker had been married for about 20 years leading up to this point. They were married in 1982. They had 2 daughters. They were separated in around 2002 to 2003. So together about 20 years. Separated for 4, 5 years, 6 years leading up to the divorce. Divorce becomes final in May 28th, 2008, about maybe 6 weeks before the murder.
Less.
Okay.
Yeah, barely over 4 weeks.
Yeah. So she's murdered on July 2nd. Now, many divorces are contentious. Many divorces seem one-sided in terms of how the resolution is done, and that was a situation here. You want to talk about that a little bit?
Yeah, so I guess what we'd like to do is just kind of talk through each of those circumstances, right? Number one is the divorce, and kind of tightly, related to that is the finances. But it is different, right? Because what the jury actually heard about was a lot about the divorce.
That's right.
And to make things a little clearer, too, there were 2 trials, really. Not a full trial, but one that ended in mistrial. We'll talk about that. It hadn't been completed yet. And then a second trial that happened long after, 3 years later, approximately. And there was different evidence that had been developed in between those 2 trials. But in any event, we'll talk through kind of what the jury saw. We don't want to get too detailed about which trials saw which
right.
evidence.
Regardless, divorce happens in July, and at the time of the divorce, at least the financial aspect of the separation, the divorce, was very lopsided, apparently, right?
That's how he felt.
That's how he felt, and that's how it was presented to the jury, and that's a key fact.
Right. That and again, we'll get back into this, I guess, like we did in the Baseline Killer and other cases, talking about other acts or situations that, so basically they were able to bring in emails and text messages between DeMocker and Kennedy, Carol, basically where he is expressing his frustration with the unfairness of the financial side. I think you have some of those.
Yeah, so the financial side of it kind of looked like this. His monthly expenses were around $30,000. He owed her $6,000 each month in alimony payments that I think had to continue for the next 8 years or so. And then, but he's only bringing in about $13,000 a month to cover those $30,000 in expenses. And so he's underwater. Not only that, there's massive community debt. And I mean, community debt is the debt that both the husband and wife had shared prior to the divorce that was allocated to him. So he's got tons of financial burden. And you're right. In the trial, there are some emails that were shared with the jury. Steven expresses some exasperation. He says, "It's a little exasperating to have settled on an agreement that provides for you as well as it does, and to be facing 8 years of writing very large checks on the first of every month, on top of spending more years than that paying off the debt that we've left only to me." Okay, he's frustrated. He says in a June 14th message, "I will not be pushed any further. You've extracted all you will extract from me." And you can imagine how a prosecutor would rely on that statement, right? I'm not going to be pushed any further, Carol, right?
Yeah.
That's tough.
Right.
Okay.
Right. Whereas at the same time, on the defense side, you and I have seen text messages. These are not particularly threatening.
That's right.
They're not particularly nasty or mean-spirited.
Right, because does pushed further means you're only getting what we agreed to and not a penny more. I will not be pushed financially any further.
Yeah.
But does that mean I murder?
Yeah, and there's not like other text messages somewhere that say, well, look, he is generally kind of guy who he does bring, say mean or threatening things. Nothing like that.
That's right. At the trial, at least no evidence was presented about any sort of violent character that he had.
No.
And the daughters testified, and the daughters said, if anything, Mom had more of a temper than Dad did, right?
Yeah. And they supported him, all the way through the trial.
Now, here, next interesting thing. So we know there's this email exchanges where he's expressing frustration over the finances. Police are able to look at his internet search history.
Well, sorry to cut you off.
Go ahead.
Sorry to cut you off. Also with the divorce.
Yeah.
I guess maybe that is related to the divorce.
Okay.
But the other piece that I found interesting on the divorce is that the prosecutors were able to bring in information about his infidelity.
Sure.
Right? Like, apparently they used the term serial philanderer.
Right.
She had told a friend at one point that she had counted 17 affairs that he
3
had.
at the same time at one point.
Pretty bad.
Right.
And this gets into that discussion we've talked about where, there's a real fine line. What is relevant to the case to prove murder, right? And of course, the state would love to bring in that type of evidence because you don't like him, right?
Right. It sullies his character.
Yeah.
Right. He's not a guy that you like, and it makes it easier then potentially to convict somebody of murder if you don't like them.
Yeah, but there's also some protections on that, right? As far as the rules of evidence. So how is it that they were able to get that in?
Well, we're going to talk about those things. We'll stick with the facts here for a second. So internet search history. So leading up to her death, he's searching for things online. Payment of life insurance benefits in the case of a homicide. Okay.
Doesn't look good.
No. Tips from a hitman on how to kill someone. How to stage a suicide. How to kill and make it look like a suicide. These are search terms that he's using. How to make a homicide appear like a suicide. Now, his laptop was recovered from the scene, or from his home. It was searched from his home by police. And his search history had been deleted. The browser had an automatic setting where it deleted the search history, but they were able to recover some of that. So let that be a lesson to you, I guess. Whatever you're searching for on the internet, the police may be able to find it.
And on your phone.
Delete does not mean delete.
No.
Okay?
No.
Got that, everybody? All right. So
now he also
what do you think of those
books.
That's right. Well,
how to disappear.
Correct. And that goes to his alibi. He actually, another thing that was presented at trial was the fact that after the murder, he had bought a motorcycle. He had gotten books on how to change your identity. Sure. He had saddlebags on the motorcycle that had like $15,000 worth of cash. He had bought a GPS device. He had bought
pretty normal.
Burner phones. Okay, when I mean burner phone, I'm talking about a prepaid cell phone that doesn't have a contract. It's basically an anonymous phone, right? Again, we're talking about direct and circumstantial evidence. these web searches then were used by the state as circumstantial evidence. And in my opinion, pretty good evidence.
Right. Damning. Right. Because it's one thing to say if the search said how to kill someone. It's another to say how it actually happened. Right. How to
stage a murder.
Stage a murder and make it look like an accident. Right. And that's what actually happened. That's bad.
So
bad for him.
Mr. DeMocker's alibi was that he was out mountain bike riding.
Yeah, that was.
He had let his daughters know, hey, I'm going out to ride my bike about 5:30 on the day of the murder. Carolyn's phone call with her mom, I think, was at 7:36 p.m. Steven goes out mountain biking around 5:30. Interestingly enough, on a trail near Carolyn's home.
Admitted. He tells them.
Right?
Yes.
He says, I should have picked a different trail. I think he should.
I wish I would have picked a different trail.
He goes biking near her home. He's gone for several hours, and his phone is turned off. Normally, he keeps his phone on, according to the daughters, because he doesn't want to miss calls from them, doesn't want to be out of touch. But in this instance, he had turned his phone off for like 4 hours, riding in the dark. Now, a lot of people mountain bike and cycle in the dark. There's headlamps and other things people use, but, he's mountain bike riding in the wilderness in the dark, okay? And then also, he says he gets a flat tire, which lengthens out the duration of his ride.
Yeah, and he'd also said that his phone had died.
That's right.
Which, again, this is so we always have to think about this is 2008, right? Or 2008. So it's technology wasn't what it is right now, but
I think the first iPhone was right around that time. Yeah.
So, but like you said, his daughters said that doesn't happen. He doesn't let his phone die.
Odds are, though, I'm going to play the odds game here and say that he probably had a flip phone, right?
Right.
Is your battery ran out on a flip phone? Fast things last for days. Anyway, we're not going to cast judgment, I guess, on those facts. Those are the facts that the jury heard, though. The phone was powered off. Maybe there was a battery issue. Maybe there wasn't. That was for the jury to decide. Now, when he does get home, his daughter is at the house, or they come in later, but he's washing his clothes and he's, kind of cleaning up. He has some scratches on his legs that he claims that he got from mountain bike riding.
Right. And then, I don't know if we want to move on to the next part of it as when police came, because it was months later that he was arrested. It was 3 months later.
Yeah, he wasn't arrested right away.
They came into the house, they did a search, and one of the big pieces was that they found a golf bag with golf clubs in it, missing the driver, with
one club,
with the one club with the head cover still there, right?
Yeah. So driver is missing, and it's a particular Callaway driver that he had ordered, and so they knew that it was part of his set, but it's not in the set. But the cover for the driver is gone.
It's just missing.
Or no, I'm sorry. The club is missing. The head cover is there,
and there's really no good explanation for that.
And they never find the golf club.
Right.
It's never found.
There was some reference to an odd conversation he'd had with his daughter, I suppose, about the club head, the cover, saying that he was driving with his girlfriend and the window was open and maybe the club head cover flew in. It didn't really make any sense.
It didn't make any sense. They do recover that cover.
Right.
Actually, they seize it from his attorney's office. It somehow made its way into the attorney's hand.
That was odd as well.
It ends up at his office. Police do a search warrant, and they are able to get that.
Search warrant on the attorney's office. Have you ever?
Well, I've been an attorney for almost 20 years. I've never had an instance where police wanted to come search my office. I'd be terrified, right? I feel like,
well, that's a
what
real
have I
problem,
done? Right?
Right, because you got client files.
That's right.
There's a real issue with that, and there's a process and procedure they have to go through to do that, but. It's not like this was just a thing. They said, they got a search warrant for the attorney's office, and that's where they found. That's a big deal that they had.
Right. It's not a common thing. And, lawyers and clients enjoy privilege and confidentiality, absolute confidentiality in most instances. But attorneys cannot be involved in destroying evidence, perpetrating any sort of crime or fraud.
Or hiding evidence.
So, again, for tips out there, legal tips, don't give some piece of evidence or some, contraband to your lawyer and expect it to remain, confidential with your lawyer. Your lawyer cannot destroy those things. Now, that can be a complex question about whether the lawyer has to turn it over or whatever, or even say anything about it.
They can advise you to destroy it.
The bottom line is it puts your lawyer in a very, very awkward spot.
Right.
And so traditionally it's not done.
And we'll see where that kind of circles back.
That's right.
That type of behavior
That's right.
of DeMocker treating his lawyer as like a tool, yeah, for kind of how he wanted to run this case. He's like he comes across to me as a guy who, he's a smart guy who thinks he's a smart guy.
Yeah, and I think he got looped into something. In fact, that's a good next fact to discuss. Okay, so police eventually arrest DeMocker for this murder of Carolyn. Okay, they believe that they've got enough now to say, hey, even though we don't have direct evidence, but if you think about the web searches, the computer, the divorce, the finances, the whole situation, they think they had enough to point to Steven, and so they arrest him. He's then in custody, and while he's in jail, I'm going to read these facts. After DeMocker was arrested, he asked his youngest daughter to visit him in jail and to bring him a pen and paper. When she arrived, DeMocker told her that someone in the jail had told him how the victim had died, how Carolyn had died. And DeMocker told his daughter to write down verbatim a story detailing that 2 men and a woman were sent to kill the victim, and a man who lived in her guest house because of a prescription drug deal involving the man in the guest house. Now, that man in the guest house was actually a potential suspect in the murder. That was Carolyn's guest house. So that man in the guest house was a suspect in the murder. Strangely enough, a few months after DeMocker is arrested, he dies apparently by suicide.
Yeah, and that's a big piece of it too. I mean, at least in the first trial, DeMocker's team really pointed to this guy as somebody who, sure, he was a suspect, but he wasn't really treated like a suspect. Like when police came, and he is living on the property where the murder occurs, he's quickly there. He's not really questioned.
But he points the finger at the husband.
And he says, she's got a crazy ex-husband, right? But they don't take his DNA.
Right.
They don't, look through, they don't search the guest house at that time. And so that was kind of we call it in the defense world, like, I guess it's not an empty chair. They're pointing to it now.
It's a third-party defense.
Right.
You're saying, hey, this other guy did it.
And they didn't investigate him.
Not really. Not really.
Yeah.
So a couple other things. So his daughter visits him. He says, hey, I overheard through the jail, that this is how this murder went down. DeMocker told his daughter to anonymously email the story to his defense attorney and to the prosecutor because, quote, it would be more credible coming from someone else, and because he thought his attorney would not believe that somebody in the jail had told him the story. So DeMocker says, this is what I overheard in the jail. Daughter, you email that anonymously to the lawyer and the prosecutor, and, perhaps it'll exonerate me.
Yeah.
Somehow.
And maybe you're going to get into this. It was wild how he talked about it, right?
Yeah, he called it the voice in the vent. He heard it through one of the jail vents.
So it wasn't somebody talking to him, telling him the story. He could hear it through the vent. Somebody was speaking it through the vent in his jail cell.
Last important fact, unless I'm going to miss something, you'll tell me. But the other important fact is Carolyn had a $750,000 life insurance policy. Because of Steven being charged with murder, Steven can't be the beneficiary to that life insurance policy. So it goes into the family or to Carolyn's trust. The trust rules dictate that it has to be used for the benefit of the daughters. Steven convinces the daughters in a sort of a circular fashion that benefit flows to them if that money is used to fund his defense team. And so that money that's in the trust from the life insurance proceeds is now channeled to his defense lawyers to represent him in his case.
And that becomes very important.
And that becomes a big issue. It actually, in part, blows up his first trial.
Yeah, and that was an interesting piece, too, where, he's actually using it as a defense as well to that particular fact, right? That they're saying, look, there's that's a very common motive argument by a prosecutor is money. He's going to get this $750,000, and their defense to it was, no, he's not. It's going to the daughters. And then they later find out that it actually was. Like during that first trial, the prosecutors learned that money had been funneled to the attorney.
Agreed. So let's jump into that first trial. So first trial starts. It's underway. that fact about the attorney receiving his funds through the trust, through the life insurance, comes to light. And that, among other things, causes that trial to stop in its tracks, because now you have a lawyer who's implicated in potentially fraudulently using these beneficiary life insurance benefits in a way that you can't do it.
And the other piece of it was, that it was all done by fraud, right? And saying that DeMocker was engaged in a fraudulent scheme.
Fraudulent schemes and artifices is the charge that they charge in Arizona. And so think about that for a minute. Think about how that affects the relationship, because when the Yavapai County Attorney's Office discovered this channeling of funds, they filed a bar complaint against the lawyer while trial is happening. In the middle of trial.
Yeah.
Right? Now you're being complained about to the state bar. Now, how do you think that affects the lawyer-client relationship?
Little information for people that might not know this. If there's a bar complaint that's lodged against an attorney, there's basically an investigative side to the state bar, who then reaches out to the attorney. That attorney often has to get counsel, usually not initially, but if it's a serious enough charge, which I think it probably was in this case, probably had to get his own counsel that was involved in the same issues in the same case that he's currently litigating.
Right,
and his client.
That's right, and the another problematic portion of it is the idea that the client, DeMocker, sort of involved his attorney in that fraud.
And it's not clear whether the attorney knew it. Now, it's hard to say, right? And so I think that ultimately is where the court came down on that. But to finish, I guess, on the other issue that I forgot about is that if that investigation shows that the attorney did act improperly, there is some type of, the state bar has the ability to punish and ultimately could take away that attorney's license. They have, there's other things that they can do to punish or to censure or but they have authority over that attorney's license to practice law.
Right. And remember, all of this is happening mid-trial.
In the middle of a murder trial.
We have a murder trial.
It doesn't get higher stakes than that.
So clearly a distraction in the trial. And now, because the client, DeMocker, is now sort of using the lawyer to commit a fraud, the lawyer says, I'm out. I have to withdraw. And there was a struggle at the trial level about whether the lawyer could withdraw at that point. Ultimately, it looks like the Arizona Supreme Court weighed in and said, no, you must withdraw. And so attorney one is now out. But think about this. The jury is still impaneled in this case. The case is still going on, right, while all of this goes down. And now DeMocker is at the defense table with no defense lawyer. So what does a trial judge have to do at that point? Can you just swap in another lawyer?
Well, and that's what they had to do, at least to take the next motions, right? Because as a represented, well, I guess he's not at that point, but as a defendant, it's really risky for the judge to allow that person to start making motions and doing things because they don't know what to do, and it's going to cause
a new
problems.
Lawyer, you mean?
I mean, before they have that.
That's right.
Right. And so they bring in an appointed counsel to at least do the next motion, which was like mid-trial motion for mistrial.
Right. And so there's a number of reasons why a trial could end up in a mistrial. One of them is a situation like this where because of, just wild things that happen, it causes the case to have to stop. Now, the practical result of this is that new lawyer could not get up to speed in the middle of trial to be able to finish trial. And so as a result of that, and perhaps some other issues, but primarily that, the case has to stop. And that's one issue that DeMocker raised on his appeal. We'll save that for a little bit later in the discussion, but trial number one ends. Okay. Then I believe about 3 years go by before they're able to start trial number two.
Yeah, and that's not unusual, right? For some of the cases we've looked at, it's been much faster than that, and it can be, so I'd be interested to learn. Part of it may be, and you're probably about to get into this, was they had added all the charges from the fraud and things
so
like
after
that.
The first trial ended in a mistrial, the state then represents the case to the grand jury. And at the new trial or at the new indictment.
And just a reminder to everybody out there, we've talked about grand juries a couple of times, but it's just an impaneled group of jurors that just hear case after case, not like a normal jury, but they sometimes are impaneled for 6 months or whatever, once or twice a week to hear these cases and decide whether there's probable cause for the case and to move forward.
And that's all the grand jury does, is determine if there's probable cause. So after trial number 1 concludes, prosecutor represents the case to a grand jury to get probable cause or to get an indictment on new charges, first-degree murder, burglary, now fraud schemes, forgery, contributing to the delinquency of the minor because he had gotten his daughter involved. And so now this new indictment gets issued. The first indictment then gets dismissed. So that case is over.
From the first case.
From the first case. But now the new indictment comes down, and you don't always have to get a new indictment to start a new trial. It's just in this case, they wanted to add more charges. And so they got that new indictment now with a whole bunch of other charges added onto it. And so, trial begins. Now, a couple of facts that we left off. DeMocker's shoe prints were found around Carroll's residence. He was apparently wearing this fairly unique hiking shoe that only about, 8,500, 8,900 of those shoes were sold, in the United States during some time frame. And then his mountain bike tire was also kind of matched in some dirt in and around her property.
And my defense heart has to clarify that a little bit, right? Which is, there was a shoe print that was found. That's a very rare type of shoe. That shoe was never found in DeMocker's home. Nobody knows where they owned it, but they were able to determine at one point in maybe several years before, he had ordered or had purchased that same shoe. So it's a little bit of a difference that I think is important to say. It's not like they had the shoes in his closet and matched it, right?
Right. And anytime you're talking about scientific evidence, I appreciate that point because I probably was a little bit loose in the way I explained it. An expert is not going to say, or at least they shouldn't say, that shoe print matches. No, what their testimony is going to be is the shoe print that was found is characteristically similar to the shoe that Stephen was known to have purchased.
Yeah. So maybe this is maybe I'm wrong here, correct me. The difference between direct and indirect evidence. It's not that we were able to directly link that shoe to that print to DeMocker. We were just able to say a similar type of shoe was owned by him at one point, right?
And a similar shoe print was around the home of Carroll.
Location, right? And the same issue is with the tire.
Same thing.
Right? That the tire is a very common type of tire.
Mm-hmm.
We're not saying that it was the same bike. We can't say that the scientific expert, nobody's going to get up there and say, yes, that was his bike. They're just saying the bike that made that track has similar or the same tires that his bike has.
Yeah. And so
now when they actually did have the bike, though, at least.
They had the bike.
Yeah.
And the bike had certain tires on it. But whether it was his bike riding around that area, they don't know. That what they know is similar tracks were around the house. Okay. So I know that was a lot, but think about all of those facts, right? The emails, the divorce, the threats, all of those things taken as a whole. That's generally the evidence that the jury heard.
One more piece of evidence that was, as a defense attorney, was gold in this first trial, which was there was genetic material found under Carroll's fingernails. And
didn't belong to her.
Didn't belong to her and didn't belong to DeMocker.
That's right. So underneath her fingernails, there was some DNA. The DNA did not belong to DeMocker, and they didn't know at that time who it belonged to.
They didn't know who it belonged to. I mean, that is such a great fact for the defense in trial number 1, right?
I'm the defense. I'm loving that fact. So because now I've got a guy I can blame it on. So
we'll circle back to
trial
what
2,
happened in trial 2.
Yeah, trial 2 comes around, and it turns out that DNA, that genetic material, was from an autopsy that was done an hour or two earlier on the same table. And I don't know if they didn't clean the table or wash their hands or whatever.
It was too close together because apparently it was under her fingernails.
The DNA was from another corpse.
That had his
how that got there, I have no idea.
Same time as hers. That is wild. I have never heard of that.
Sloppy, for sure. Sloppy. And that's not as powerful as we don't know who it is. Now you're just saying this crime lab is awful.
These guys suck.
They're terrible.
Yeah.
Right? So the case is presented again to a second jury. And DeMocker is convicted of almost all of those counts. Now, a couple of the forgery counts related to the email that was sent to the lawyer and the prosecutor, those were actually dismissed by the court after the evidence was presented by the state. The judge has the authority, if they don't believe that sufficient evidence has been presented, a judge can stop those from going to the jury under what they call a Rule 20 motion. That was done. So a couple of those get knocked out, but they're not important counts.
I would love to get into the details of that, and maybe we can post that in the show notes or something somewhere. But one of the things that they actually charged him for was a fraud about hearing the voices through the vent.
No.
A bizarre charge to say, no, that didn't happen. I get it, right? Like, that sounds a little outlandish. How do you prove that, right? So, and that was one of the ones that was dismissed.
Right. But I'm going to call those throwaway counts. They don't matter. They don't affect the outcome. The reason a prosecutor charges counts like that is so that they can talk about them and dirty up somebody, and not because they want some extra punishment. It's so they can say, hey, these are charged in the indictment, so we can talk about it.
It's exactly what we were talking about earlier, where you get to talk about things that now have become relevant because I charged him for it.
That's right.
When maybe I couldn't have brought that in before because it really has nothing to do with whether he killed this person or not.
Right. It's dirt.
Yeah.
So let's now that we've laid out the facts, let's go through some of the key issues that he raised, because he was convicted, and so then he takes his case up on appeal and says, hey, my first and second trials were kind of screwed up. And so here's some issues that I want to attack now after the fact. So one of the first issues that he decides to attack is the search of his home, his workplace, and his car, because police did find some evidence, there, for instance, the computer and the searches, right? Police, though, got a warrant. Now, under the Fourth Amendment, searches of private places like your home police have to have a warrant in order to get inside there. And they did in this case. It's not like they conducted some warrantless search. DeMocker's attack on that search, though, was the affidavit or the facts that allow the judge to find probable cause to search. Those facts were not 100% correct. And so he filed what we call a Frank's motion that says this warrant should be invalid because some facts in the probable cause statement are not true.
Yeah, and so maybe you can tell us, I mean, the basis and the rationale, why is that something that a judge would look at and say, okay, well, then I'm going to throw out the warrant?
Well, because if the judge who granted the warrant was misled about what the facts are, then maybe there wasn't probable cause to search those places. Therefore, the warrant is invalid, the search is invalid, and now the evidence can't be used. And so if as his defense lawyer, I can toss out, say, those internet searches, I want to do that. And so they did try to do that at the trial level. The trial judge denied that motion. And on appeal, the Court of Appeals says, yeah, the trial judge did it right. Because the facts that DeMocker took issue with were very inconsequential facts. They were things like the exact time that he left out to ride on his bike, or the duration that he was gone, or other things that didn't really bear on whether there was probable cause or not.
Yeah, and that's really, you can look at it from the defense perspective, right? Well, I'm always looking at it and what rights are we protecting from innocent people being charged, right? And you could imagine a situation where an officer thinks he knows that somebody did something.
That's right.
And they want that warrant, right? And they think that there's going to be something there, but they just don't have the facts. If it weren't for something like a Frank's motion to be able to challenge that, they could just make up whatever they wanted so that the judge thinks there's probable cause. And then later you challenge it and they'd go, well, sorry, if they thought they had probable cause at the time. And so it's the opportunity to go back and say, we're not going to allow officers to just give false statements to judges in order to get a warrant.
But in order for that Frank's motion to be successful, the facts have to be important enough to deter probable cause, or to say that there is no probable cause. Here, they weren't that important. In addition to that, officers and the judge finding the warrant to be valid or signing off on it is given a little bit of latitude. There is sort of what they call a good faith exception. Let's say that officers thought that the facts were, A, B, and C, and turns out they're, X, Y, and Z, or slightly different, but the officer believed in good faith that such was the case. then that good faith exception may save that warrant. And here, it didn't even really have to reach that far. The facts that he was saying were different were really not that important. And so this judge says, hey, search is valid. All that evidence that came in as a result of that search, it's still in.
Yeah.
Okay. The other part of it, and I think this one is really important, is the fact that that first trial ended in a mistrial.
This is an interesting argument.
So this goes back to everyone's Sixth Amendment right to not be placed in jeopardy twice, right? So you can't be tried twice for the same offense. Now
Double jeopardy.
Double jeopardy.
Yep.
Here, DeMocker was tried twice. The first trial didn't finish, and DeMocker's argument was, hey, it didn't finish because the prosecutor meddled with my relationship between me and my lawyer and caused that first trial to end prematurely.
Because they did a bar complaint, because
Right.
they did all these things, yeah. And that's a legit argument, right?
I think that's a terrific argument by DeMocker, because it really was the prosecutor who intervened in that relationship, saying, hey, your lawyer got these funds from the trust and committed a crime on the court or a fraud on the court and so forth. And, they're the ones who really caused that mistrial.
Yeah, and sorry, to go back on that, double jeopardy, how it works, right, is that you can't have two trials for the same crime. The idea was, obviously, the state can't try somebody, get them found not guilty, and then they just try him again. That's when they can just try him 10 times until they convict him. And it's a, very technical way that it works, because you could go all the way up until you're about to pick a jury or a jury's about to go. They could dismiss at that point, and then they can charge you again. And that happens all the time. But once the jury is selected, it's what they call, the phrasing is that jeopardy attaches at that point. And so in this case, a jury had been selected, jeopardy had attached, and then mistrial happened. But you're going to go into it more.
Right.
Why that didn't save the day for...
and so the standard on a mistrial like that is caused by the prosecution is whether the prosecution acted in bad faith to cause the mistrial. And here the Court of Appeal says no. They point the finger at DeMocker and they say, look, you're the one who engaged in this fraudulent behavior. It's not the state's problem or fault that they discovered that midway through the trial. You had committed an offense that a jury later found you guilty of, a second jury. And the prosecutor's actions here were justified. And so just because they got the ball rolling with the mistrial doesn't mean that it's not DeMocker's fault. At least that's the way the Court of Appeals looked at it.
Yeah, and they didn't, I think part of that key was they didn't do it in order to get a mistrial, right? They wanted a mistrial, so that's why they did it. They did it because an offense was committed, right? And they learned about it.
Devil's advocate here, though.
Right.
I'm gonna do some. I'll quiz you. Would you rather have had the jury give a verdict in trial 1 or trial 2?
If you're who?
If you're to the defense.
1.
I want trial 1.
Yeah.
Because I know I've got some things in that one that I can argue.
That DNA.
I know the DNA.
Yeah.
So my argument would be, as the defense lawyer, Judge, this case isn't going very well for the state, and that's why they did all this.
They knew it.
Right.
Yeah. Yeah.
I like that argument, but obviously the higher court saw, through that, and so did the trial court. They said, no, we're not going to, say that the state couldn't have mistried that case and they couldn't have tried you again in the second indictment.
It's kind of similar but different, right? Do you remember when Joe Arpaio was being prosecuted and he allegedly had deputies following the judge and the judge's wife, right? So then they find out and they get upset about it, and he says, Judge, you got a conflict off now because my guys were following your wife. And the judge says, well, you can't create a conflict and then...
And that's essentially what the Court of Appeals does, is they're saying, look, you, DeMocker, you created this circumstance. The state just happened to discover it.
And they did what the state does at that point, yeah.
Okay, so no go on the double jeopardy argument. The other argument, and we saw this in Godot, was severance. Okay, remember, charges can be joined if they're the same or similar character, or if they're committed as part of a series of acts. The state had gotten another indictment adding on all these charges, and DeMocker says, whoa, yeah. I should get separate trials as to the fraud part versus the murder part, because those are not the same thing. that the trial court says, nope, everything's coming together because it's part of a connected series of acts, right? And much of the same evidence in one trial is used to prove evidence in another trial. So those trials have to be joined, or they can properly be joined. And then that ugly monster rears its head again, 404B, right? We talked about this during Baseline Killer.
Other acts evidence.
Other acts can be crushing for the defense.
It wins or loses case. We said that last time. It can win or lose a case, and that's, I think, what this is all about.
So what are some other acts that are not charged in the indictment, but were presented at trial? The affairs. We talked about.
I think that was huge.
The computer searches are technically another act. It's not a crime to search for how to hire a hitman, right?
Nope.
And in fact, in his defense, DeMocker actually claimed to be writing a book.
And his sister backed him up.
Right.
Said she'd been editing it.
Crime book.
Yeah.
That's why he did these internet searches. But those searches come in. The emails with the ex-wife, with Carolyn, about money problems, those come in. Those are, again, other acts. His plans to flee, the motorcycle, the $15,000, the GPS, the burner phones.
Yeah,
they don't able to present that evidence.
Yeah, they don't go to whether he committed the murder at the for this
Correct.
case. But so talk us through, Dave. You're our 404 guy. Walk us through why those came in.
So there's a number of 404B arguments. Number one, it affects the credibility of witnesses. Okay. Bias and credibility is always relevant for the jury, but more importantly, directly under 404B, it goes to motive, intent, opportunity, premeditation, which is an element, flight, consciousness of guilt. There's half a dozen arguments as to why those pieces of evidence can come in.
It wasn't close, right? It wasn't close on this one. Sometimes it's a really tough call for judges. This one was kind of clear, right, on those exceptions and why it came in.
Yeah, and it's crushing for the defense. We want to keep those things out, but when a judge says, nope, they're coming in.
Yeah, and we talked
now
about
you got to deal with it.
We talked about this last time. I mean, they even tell the jury, you don't get to use this for the purpose of saying that because he did these other things, he did it this time. But they're humans, and that's what we do.
But here it's even more, the relationship between those other acts and the crimes themselves are even closer. Because when you're on your computer saying, how do I stage a crime scene to look like a suicide, or a homicide to look like a suicide?
Or like an accident.
Yeah. Or an accident. I mean,
and then that's what happened.
It's pretty clear, I think. And so not a close call. The other thing that he took issue with prior to trial and then raised it again on appeal was the use of these shoe prints and bike prints.
Yeah.
He attacks the expert nature of it. So in order for that evidence to come in, it has to be relevant, and it becomes relevant through expert testimony. So state presents somebody from, I think, DPS and the FBI to say, I'm an expert in shoe print comparison. I looked at these prints. I looked at those shoes, and using a methodology that is generally accepted in the scientific community and that is, supported by peer-reviewed studies and other sorts of analysis, I've come to the conclusion that these are similar footprint or a shoe print to the shoe. That's what they were able to present. Same thing with the tires. Now, they were limited. They couldn't say they were a match like we talked about. But DeMocker wanted to keep out that expert testimony, and the state was able to show that, yeah, it meets that scientific threshold. So, scientific evidence, especially if it's novel, like if you're dealing with new scientific theories, it can be more difficult to get in. But tried and true, tested scientific methods will generally be allowed in trial.
Or if they go too far in what they're trying to say it proves, right? So like if they try to say that it was a match, right, or they try to say, yes, this excludes all other shoes. It was his particular shoe and, that
But this is something that I think illustrates how you do defense work. You don't settle for anything. I'm not going to assume that, or just stand idly by while the state tries to present this shoe evidence and tire evidence. Because I'm going to say that stuff is junk science. It's not applied. You can't solve anything from these things. And I want to keep that bit of circumstantial evidence out.
Because it's misleading, right? Because it makes the jury think that there's more reason to believe he did this than there is.
Right. Guy comes in his lab coat and his glasses, and he says, look, I've properly applied the comparisons here, and the shoe fits.
Right. But it's like people kind of miss the nuance that they're not saying it was him. They're not saying it was his shoe. I think they miss that sometimes, and they see, oh, well, the shoe it must have been his shoe.
Yeah, and I think juries sometimes give too much weight to expert testimony, And so as a defense lawyer, you have to attack that, even in things like a DUI case. Whether the blood was analyzed properly, whether the officer did those field tests correctly, the science has to be applied in the right way. And so as defense lawyers, we attack and we attack and we attack. Sometimes we win. What are things that you can kind of put your opinion on or give your thoughts about as we wrap up?
Yeah, so this is one of those cases that just makes you understand a little bit more, I think, about circumstantial versus direct evidence, that it can be frustrating. Like for DeMocker's daughters, it was shattering. They believe that he did not commit this offense. There's no way he could have, and that he was wrongly convicted because all these circumstances lined up in a way that told a story that wasn't true, right? And that's kind of the whole reason that we're supposed to have this standard of saying, if we're going to convict somebody of a crime, I don't care if it's littering or if it's murder, the state has to prove that case with facts and evidence beyond any reasonable doubt. There can't be a reasonable alternative explanation to it. And sometimes we're wrong. I'm not saying they got this wrong. I don't know. I wasn't there. I wasn't in the jury, and I didn't hear it all. It's just that sometimes, it can be hard to swallow on a seriously, I guess, serious case, and that there's no direct evidence.
Yeah, think about all the evidence that's not there. Let's spend a minute on that. They don't have the golf club. They don't have the murder weapon, right? There is no DNA from DeMocker at that crime scene. None.
Even though there was blood everywhere.
None. Blood everywhere. None of it's his.
If he got a scratch on his leg,
there's a neighbor.
Why is his blood not?
Well, the guy living in the guest house on Carol's property commits suicide shortly after she gets murdered.
They also had evidence that he had been threatening to women in the past.
That's
and
right.
Had issues with his
and that came out in the jury, in front of the jury. So there is a host of evidence that's not there.
No eyewitness evidence.
Nobody to
say, yes, I saw him in this location or doing this. Nobody.
He just happens to be out on his mountain bike, riding, and that occurs at the same time that she's dead. And the state says, we've got motive, we have opportunity, we have intent here. Okay, maybe you do have a number of things that sort of point to DeMocker, but if I'm the defense, I'm going to say, look at everything you don't have. Look at everything that is missing, and ladies and gentlemen, how on earth is this proof beyond a reasonable doubt? You cannot convict this man.
Just, again, you go back to how much of it mattered that they were able to talk about what a bad dude he was because of his infidelity and all these kind of things, and how much does that play into it?
I'm going to pose a question to you, because I think part of the problem that DeMocker had was he kind of meddled too much. The email.
That's the thing. Right? He's a guy who's smart, and he thinks he's smart.
But the email, the trust funds, for a moment, take all of those things out. Act like they'd never happened. Now you have a circle of evidence that's now is much smaller. There's fewer points towards your client. I think
better shot.
In
fact, we know that that's true because in trial number 1, a lot of that evidence did not come in about the divorce.
That's right. So, again, it's a good case to think about. What is a circumstantial case? What does it mean? Where is there doubt?
Don't meddle in the case.
Don't mess it up.
Yeah.
Don't do things like that after the fact. And again, we're not counseling people to commit crimes. I want to be very clear. That's not the motive. But be very careful, right? I mean, I think part of the missteps here was he was trying to manipulate the situation after the fact, and it looks bad.
It looks bad. And the thing is, you could argue that an innocent person might do the same thing too, right? Sure. That if you're being charged with a crime that you didn't commit, you're desperate.
That's right.
To make sure that they get the right outcome. But it just hurts you.
It just played into the prosecutor's hand.
Yep.
It gives them a much stronger case. So interesting case. Again, part of Arizona history. I think this case was a big deal at the time up in Yavapai County. Love learning about these things. Love discussing them with you.
Appreciate you, Dave.
Appreciate your time.